Nice to meet you here, guys. Thank you for coming for our meeting. This event is organized by researchers of the research group in Sociology of Law, which is the part of Institute for Comparative Studies in Conflict Management of Fluminense Federal University. The event has received financial support through projects funded by FAPERJ, CNPq, CAPES, and the INEAC, our network of researchers in Niterói. The research group on sociology of law was created in 2017 at INEAC as a teaching unit at university. This is an initiative introduced by the INEAC and organized reflections on socio-legal research produced within the group. We owe too much to this environment of incentive to research and incentive to research and innovative provided by this network of researchers. These research seminars seek to discuss the organization of legal professionals, which we call legal operators, emphasizing the relationship between professional socialization and institutional practice of conflict management in Brazil, through the presentation of the experience of professionals in their forms of organization, as well as through the investigation of the common daily routines of courts and offices. Recent controversies surrounding the decisions of legal institutions on political scandals have caused great repercussion and public visibility, in addition to sensible disputes over their legal and political meanings. Although central to Brazilian political sociology, the discussion about civil rights is treated marginally in public debate that takes for granted the way legal operators exercise their power. The exercise of power is at the center of socialization, professionalization, and daily practice that socially organized law in our society. Professional corporations have also played an important role in supporting and opposing the views of professional politicians who represent citizens. Thus, the rationality of the legal operators eclipses the rationalities of professional politics. Legal decisions have produced great consequences and implications for party political relations, but also for society. This process has challenged the electoral process. It also produced widespread suspicion about political parties and their practice of financial, negotiating, and voting laws. The narratives confront on the one hand, the ethical reveal, the ethical cleaning, a fight against impunity, a fight against corruption, a political renewal, in order to depreciate politics. And on the other hand, the coup plotters, the reactionaries, the widows of the dictatorship, and the coxinhas, how we call the people that support Bolsonaro, and the fascists. The polarization still has repercussions on the daily lives of Brazilians and is reflected in the political electoral debate. Legal technicalities are discussed on television before an audience that observed bestialized, to take up the expression of José Murilo de Carvalho, a Brazilian historian. Legal issues still seem too opaque for the entire national debate on the role of the powers of the Republic in the administration of political and legal conflicts. The narratives sometimes praise the judicial and police bureaucracy, and sometimes mistrust the work of this institution. From the different sides, the field of disputes is not clear as one might wish. These inquiries naturalize dogmatic knowledge about law institutional practices, and the monopoly of legal professionals in Brazil. The explicitness of political positions has not produced greater knowledge about the law, its practices, and ways of understanding its meanings. Legal professionals use language to address these issues as legal technicalities. In this way, they exclude the public from the discussion and ignore how they produce their legal consciousness. Explaining the way in which legal operators intervene in society continues to challenge the sociology of law. It is not possible to understand these social phenomena without taking into account how they produce the meanings of conflicts, professional ethics, and the content of practice of legal institutions in Brazil. The objective of this seminar is to articulate a research agenda with legal operators on the socialization of jurists, the forms of knowledge of professionals in action, and the institutional practices of conflict management. The approach seeks at one time to understand the forms of production, social organization, and reproduction of socially constitutional knowledge as law. The legal professionals as a set of protections and social professional disputes and legal practices as the result of moralities in context and in action. The organization of panels contemplates these objectives, allowing researchers to discuss amongst legal operators their views on the powers of the legal professionals in Brazilian law, the policies of access to justice and citizenship services, and the dilemmas of the decisions, the challenge of equal treatment for the legal professionals and the training of legal professionals. The event includes the participation of many researchers from the research group on sociology of law, 15 to be more specific, whom I thank for their support and participation in this event and in the different professional meetings and discussion during the last 9 years in which I've worked professionally at university. I'm gonna just pass. Well, the interdisciplinary character of our event allow us to continue the dialogue between social scientists and legal operators. In the past decades, I have supervised and co-supervised studies which are important for the production of policy-oriented knowledge. And so I work on with three policies of production of knowledge here in university. The first policy is to value the practice of ethnographic description to legal practices in its phenomenological dimension, seeking to identify the interactional production of legal categories and records. Second, to further develop an interdisciplinarity knowledge, taking into account intelligibility as a challenge posed to legal operators as they are confronted by sociological and anthropological knowledge, especially a political sociology of the practice of legal operators of law, of legal operators, I'm sorry. To contract, and the third policy to produce knowledge is to contrast the theories and practices in other countries to Brazil, as well as the ways of learning and recognizing what is the law in our mundane experience. The event will bring together legal operators and researchers to discuss the professional challenges which is of interest of the society. We hope not only to open new possibilities for exchanges with academy and legal institutions, but also to contribute to produce greater intelligibility about the meanings of the professional disputes and the tensions experienced by legal operators. And today we have here with us Sigurd D'Hondt of Jyväskylä University from Finland, with Fábio Ferraz, which is a postdoc researcher in his laboratory in the project of research about the International Criminal Court. So I'd like to thank you so much for coming to present us your project. I hope we may find some way to exchange more, and our research group may help you to, in a way we may find, to collaborate with you. And because we think that international research about sociology of law may bring us some light of how you construct the problems, but also how your institutions create the experience of law, which brings much more previsibility, much more constraints to citizens and public services, and much more security in the way you make the law in your everyday life. So these discussions will help us to understand many of your challenges, and may, by contrast, help us to understand our national challenges in Brazil. So thank you so much, Sigurd and Fábio, to taking a piece of your time to present to us this project. You have the la parole.
Okay. Thank you, Pedro. Thank you for this very thoughtful introduction and these kind words. Thank you for this introduction and this opportunity to present our work in these pandemic times where nothing is taken for granted and everything is a bit insecure. I think it is opportunities like these that provide us the opportunity within the academic community to find some joy and to be able to exchange and share. Even if you can't travel, at least we are having these technology mediated exchanges, and you know, it gives us some energy to keep us going. So Pedro, thank us for that. So I very much enjoy this opportunity. At the same time, I should admit that I'm a bit nervous, and nervosity on my part has to do with the fact that, as you may have noticed, I'm currently based at the linguistics department, and most of my background is in linguistics. I mean, not the hardcore linguistics of grammar and phonology, more the linguistics that focuses on language use. But, you know, each time I have to present for an audience of legal scholars and legal professionals, I'm a bit uncertain. But then, you know, Fábio warned me in advance that you are a very kind and a very nice audience. So that kind of, well, so I'm confident
don't worry, Sigurd. As you may see, we are trying to construct relations. It's very hard to do, as you may know. And so I'm nervous too, but I think it's a great opportunity to meet someone that I've met, I don't know, 11 years ago, in 2009 in Kashan. So this is an opportunity. And well, we don't know more about linguistics, so you know, we may help each other. Maybe I can understand a little bit more about the Brazilian law, but not an experience, an European experience as you.
And anyway, disciplinary boundaries are there to be broken, I think. So sometimes one has to be blunt and just move into territory one is less familiar with. Okay, I had told you I would prepare a kind of animated PowerPoint. Unfortunately, I did not have time to finish this in time, so I will just be having a regular PowerPoint and do the talking live in the meantime. Okay, I'll be sharing my screen with you now. Okay, this, as you may know or you may not know, is the building complex in The Hague of the International Criminal Court. If you once happen the opportunity to visit The Hague, please go there. It's a very interesting building. The architecture in itself is a research, could be a research topic in its own right. And I'm just preparing an article that deals with the architecture. Okay, for this presentation, however, I'm going to give a more general overview of our research project, negotiating international criminal law, a courtroom ethnography of trial performance at the International Criminal Court. But maybe before I start with the presentation, I should maybe just give you a very brief explanation of how did I arrive at this topic? I mean, what triggered my interest in international criminal law? Well, actually, my interest into international criminal law started 6 or 7 years ago when I was still teaching in Ghent at University of Ghent in Belgium at the Department of African Studies. I was teaching linguistic anthropology, social linguistics, with a strong focus on interaction and on interactional practices. And I had done some research on intercultural communication in Belgian courtrooms, but then not specifically on international criminal law, but then at one day, a person from the other side of the corridor, Bas Lecoq, then in Ghent, now in Berlin, came to my office and said he wanted to talk to me about a research project that he wanted to start. A research project on specifically dedicated to Mali. Bas, my colleague, was a historian working with the regional expertise on West Africa. Basically Mali, and on that time, still going on, there was a civil war going on in Mali. And his idea was to set up a collaboration between regional experts, historians, and a linguist with some background in legal discourse in order to develop a kind of monitoring tracking system to study the multiple transitional justice initiatives that were at that time going on in Mali. There had been a civil war, I will be talking about that later, which had started in 2012, was not yet entirely concluded, was still going on, the conflict was still a bit lingering. But at the same time, there were multiple transitional justice initiatives going on, trying to restore peace. And his idea was to bring people together with various backgrounds to trace these ongoing transitional justice initiatives. A kind of history in the making. We are studying historical processes as these historical processes unfold. A very interesting conglomerate of researchers. And we submitted a number of projects, 2 or 3 projects, which almost got funded. A very frustrating experience. You submit a research proposal, you make it to, you arrive at the very final stage, basically the stage where things get political. And at that stage, someone decided, okay, you know, sorry, but you guys, you don't get the money, go somewhere else. And, you know, you're left with the feeling, okay, you have a decent proposal, something that could deserve funding, but it doesn't get the funding. After a number of these experiences, my regional colleagues lost interest. Life goes on, you move on to a different field, a different interest. But I mean, for me, one good thing about going through these project applications was that I developed this interest in international criminal justice, and at least my colleagues moved in a different direction, but I kind of developed this interest in international criminal law and the International Criminal Court. So that is a bit how I arrived as an Africanist studied, an Africanist interested in legal discourse, but also in various African social linguistic settings, how I came to be interested in the International Criminal Court. And in the meantime, a lot has happened. I moved from Ghent University in Belgium to Jyväskylä, but that's a different story. I won't go into that today. Okay, let me Oh, sorry, and that was a slide too much. The previous slide. Okay. Briefly, some information about the project. Project is based at the University of Jyväskylä in Finland at the Department of Language and Communication Studies. Project studied by the Academy of Finland for 4 years. There's an internal research team with Juan Pablo Perez Leon Acevedo, Fábio, whom you've just seen, and Elena Barrett, which is the local research team. At the same time, there are a number of external collaborators involved in this project, one of whom is Baudouin Dupré, whom I assume you've met yesterday, and the other one is Jonas Benz, a legal anthropologist connected to the Freie Universität in Berlin. Okay, in my talk today, I will basically doing 2 things. First of all, I'll try to explain to you, make clear to you the rationale behind the project. Why an interaction analytic perspective on international criminal justice? What can linguists, interaction analysts, ethnographers, people like me, contribute to international criminal justice and study of the ICC? That will be my first part. In my second part, I will talk you through a number of instances. I will try to explain some research data that we discussed so far, and then try to give some examples of interaction analysis applied to the International Criminal Court. Okay, starting point for our inquiry, for our project, is basically the fact that the ICC very much represents an emergent judicial paradigm. The Rome Statute, the international treaty that founded the ICC, and the treaty, also at the same time the text that contains its basic fundamental procedural law, was adopted less than 25 years ago, in 1998. The International Criminal Court itself became operative in 2002. That is less than 20 years ago. In these 20 years, the ICC opened investigations in 13 different countries, 13 different situations, as they are referred to in the terminology of the ICC. The ICC opened 28 cases. 9 trials have started, starting with the Lubanga trial in 2009. And 9 trials actually is not that very much. So there have been only 9 trials conducted before the ICC. Of these 9 trials, there have been 4 convictions: Lubanga in 2012, Katanga 2014, Al-Mahdi 2016, Bemba in 2018. There have been 2 acquittals. 2 trials are currently at appeal stage. One, Bosco Ntaganda, who was found guilty in 2019, but appealed by the defense. There has been Bagbo, who was acquitted in 2019, but the verdict was appealed by the prosecution. In addition to the 2 cases under appeal, there are 2 other cases that are still going on. The trial of Dominic Ongwen, an Ugandan warlord, a trial that started in early 2016. And just last week, it was announced on the ICC website that the chamber will render a verdict, I think, on January 12, 2021. January 12th next year. That is a little less than 2 months from now. So at the moment, we are very eagerly awaiting the verdict. There's another trial, the trial of Al-Hassan, a Malinese Islamist, a trial that started only recently in July 2020, July this year. And there is one more trial that it will start in 2021, and that is a trial related to the situation in the Central African Republic. So all in all, court has been around for 20 years now, but the number of trials has been rather limited. So it's still very much a court that is under development, one might say. So in that sense, as an emergent judicial paradigm, the ICC is very much a legal laboratory. A legal laboratory meaning that law is developed along the road. And as such, part of this emergence has also to do with the fact that the ICC is confronted, as a legal laboratory, the ICC is confronted with multiple challenges, both internal challenges and external challenges. Let us start with the internal challenges. And this is a quote from Richard Wilson from 2016. Well, internal challenges, basically, if one looks at the International Criminal Court, the ICC represents, and I quote, a hastily patched together, unstable amalgam of Anglo-American common law and continental civil law traditions. So basically, when the ICC, when the Rome Statute was drafted, the Rome Statute is very much a compromise between different legal traditions, a compromise that was drafted on paper. But, you know, there is, of course, the question, how will this compromise work out in practice? So the compromise manifests itself in the way the evidence is presented. The way evidence is presented before the ICC very much resembles the accusatorial common law tradition, in the sense that each party calls its own witnesses, and each witness is cross-examined by the opposing party. So the presentation of the evidence is very much borrowed from the common law system. On the other hand, however, the judge is the central truth finder. So the judge plays a much more active role than would be the case in a strictly accusatorial Anglo-American system. So if you look at trial transcripts, you see this very awkward assemblage of practices that you find in common law system and practices that you find in civil law systems. And this tension between the two systems is something that is very much negotiated as trials continue and as trial practices before the court develop. This is also reflected in the position of the victim. Within purely accusatorial systems, the victim is a witness. In inquisitorial systems, the continental systems, the victim is very much a party to the trial, la partie civile. The partie civile, as called in French. Now, the Rome Statute takes a kind of intermediate position. The Rome Statute states victim participants have the right to express their views and concerns when their interests are concerned. But basically, if you look at the Rome Statute, that is about it. You know, and then there is the whole question for, okay, expressing your views and concerns. How should that be done? And, you know, there have been trials where Bemba, we just looked at some Bemba transcripts this morning, the Bemba trial, and that was in 2012, there was a victim who made victim impact statements, very much like would be the case in Anglo legal systems. But one of the other trials that we're currently looking at, the Ongwen trial, there are no victim impact statements, but there the victims are called as witnesses by the legal representatives of the victims, and the victims are actually presenting testimony. So this whole question of the position of the victim, which is stipulated in the Rome Treaty in very rudimentary terms, I mean, the format in which this should actually be done is very much negotiated as trials proceed and as trial practice before the ICC develops. So that is kind of the internal challenges which the court is facing. Basically, judges had to start with a pile of paper, 2 documents, the Rome Treaty and the Rules of Procedure and Evidence. I don't have them with me, but it's basically, you know, 30, all in all, I printed them out for Fábio. It's one is 50 pages A4 and the other would be, well, about the same, I think.
Yeah.
Mm-hmm. And, you know, on the basis of these 2 documents, judges face the task of, you know, okay, make sure there is a trial and make sure the trial works. So there is a lot of creation and a lot of invention going on as trials proceed, as trial practice develops. Okay, at the same time, the court is facing external challenges, and very often these external challenges take the format of legitimacy issues. Legitimacy issues are to a certain extent, one might say, inevitable. Inevitable because, well, basically because the court is such a very recent institution. Domestic legal systems had the time to slowly accumulate legitimacy over hundreds of years. The ICC was created only 20 years ago. So in a way, the disarticulation of law on the one hand and the political process through which the law has been instituted is not yet entirely complete. One might say that the law still bears the imprint of the act of its own institution. So it did not have it just did not have enough time to accumulate legitimacy. It is still in the process of accumulating legitimacy. And this is in turn aggravated. Well, one tricky element is the referral procedure. Cases can be referred to the ICC by states. The situation in Uganda was referred to the ICC by the Ugandan government. Situation in Mali was referred to the ICC by the Malian government. One way of starting a case before the court. At the same time, the prosecutor can start an investigation proprio motu on its own initiative. Can start an investigation on its own initiative, but then there is a third way for approaching the court, and that is through the UN Security Council. The UN Security Council can refer a certain situation to the International Criminal Court, as happened, for example, in Sudan. Now, of course, the problem there is that the Security Council, not all members of the Security Council themselves have signed the Rome Treaty and recognize the International Criminal Court. For example, Russia, China did not sign the Rome Treaty. United States did sign the Rome Treaty, but never ratified the Rome Treaty. So you have this asymmetrical situation that Security Council can refer cases to the court, even though not all members of the Security Council recognize the jurisdiction of the court. So there is some tricky issue there as well. One could add furthermore that this inevitability of legitimacy issues is further aggravated by geopolitical shifts, geopolitical transformations that occurred after the signing of the Rome Treaty. The Rome Treaty, the Rome Statute was signed in 1998, the end of the 1990s, and as such, it was very much the product of post-Cold War optimism. Well, the Cold War has ended. There is no longer this ideological conflict between these two power blocks, and from now on, relationships by states will be governed by the rule of international law. A very optimistic narrative. And, you know, we did have the tribunals in Yugoslavia and in Rwanda, which sort of strengthened this image. So the 1990s were very much a period of optimism, a narrative of a new period in the history of international relationships. A new period where international relationship would be governed by international law. That was 1998. Now the court started working in 2002, and by that time the geopolitical landscape unfortunately had very much changed already, and that of course had to do to a large extent with 9/11, the 9/11 attacks in September 2001. And also more specifically, response by the United States first the attacks on Afghanistan, then the war in Iraq, which more or less demolished this optimistic narrative and, made clear that, well, international law will just be business as usual. Some of them became clear in a very brutal way that some of the most important players on the world scene did not consider themselves very much bound by these international institutions. And basically, one could say that the attacks of 9/11 drastically altered the geopolitical landscape the ICC had to navigate. Adam Branch, in an article from 2018, states that basically, because of this changed global landscape, the ICC prosecution had to go after weak targets, and very often it had to go after opportunistic alliances with other state actors in order to make sure that people would appear before the court. So this new situation of going after weak targets very much resulted in the accusation of the ICC being a neo-colonial court, the ICC having an African bias, and in a way, if you look at the cases that have been tried so far, okay, recently new investigations have been opened into Georgia, Afghanistan, Myanmar, also Palestine, Colombia, Venezuela, Bolivia, some still at the preliminary stage, but you cannot recognize that this first group of situations that were investigated and the first trials were all related to situations on the African continent. And so, and that's a kind of unfortunate situation that geopolitics affected the landscape in which the ICC had to operate. And this, on the background, lures an even more pressing issue. And there is a question, one might pose the question whether criminal law is actually a suitable instrument for prosecuting political violence. To what extent is criminal law indeed the most suitable way to go after political violence? And here we are confronted with something that Maxine Kamari Clark in her 2009 book refers to as legal encapsulation. Basically, the legal liberalist paradigm, a legal paradigm that puts a lot of emphasis on individual responsibility, the legal liberalist paradigm produces a particular kind of perpetrator, and that is that of the African warlord. The typical perpetrator that appears before the ICC is the African warlord who has no respect for human rights, who just is engaged in endemic circles of violence, and in a way that is very much a decontextualized image of the perpetrator. This legal liberalist paradigm, which goes after individual responsibility, very much ignores the broader political context in which violence is taking place, who benefits from the violence. For example, if we look at situations in the Democratic Republic in Congo, for example, the political instability. I mean, political instability is almost, of course, there are these African warlords and there are these African actors, but behind the scenes, there are also economic interests playing out. It's an area that's very rich in minerals, and this whole broader political spectrum, disappears out of sight through such legal encapsulation. This also has to do with the fact that in the end, the ICC only has jurisdiction over only 4 crimes: crimes of genocide, crimes against humanity, war crimes, and aggression. If one looks at preceding discussions on international criminal law that had been going on since the 1980s already, the scope of possible crimes was much broader. Initial discussions also featured, for example, crimes such as colonialism, hiring mercenaries, which indeed have much more political content. But in the end, the Rome Statute only focused on these 4 specific crimes. So there is this legal encapsulation that kind of ignores the broader picture. And that kind of further, okay, if we talk about these legitimate issues, in the end, we might pose the question, is criminal law indeed the most suitable instrument for addressing such violence and addressing such political issues? Okay, so if the ICC represents an emergent legal paradigm, a paradigm that faces multiple challenges, then of course our project is concerned with the question, how do we analyze this emergence? How do we analyze these challenges, and how are these challenges dealt with? And basically, there are multiple answers possible to this question. One way to analyze the emergence of the International Criminal Court is through a sort of institutional history of the ICC. An institutional history or a sociology of the ICC would be one possible solution. One could also approach the ICC from the vantage point of positive law and try to sketch the development of a new legal doctrine, looking at the new law that is produced in the Rome Statute and in the various decisions of the trial chambers, etc. That would be very much a legalistic approach. Now, what we do in this project, or what we try to do in this project, is still a kind of third type of approach, and that is opening up, and that is trying to open up the black box of what goes on inside courtroom talk. So basically, our project is asking the question, how do different actors in an international criminal trial, magistrates, attorneys, etc., how do they behaviorally navigate the various tensions, internal tensions, external tensions? How do they behaviorally navigate these tensions while they interact with one another at the court? So we want to study these tensions and how the ICC emerges in response to these tensions by looking at actual trial practice and by an ethnographic picture of actual trial practice. In a way, you could say that we are trying to produce an empirical snapshot of how this emergent transnational legal order, this emergent transnational legal system consolidates itself in action. We're trying to develop, as Baudouin would say, a kind of praxeological perspective on this process of legal consolidation. And for this, we draw on the toolkit of linguistic anthropology, and more specifically on the toolkit provided by interaction analysis. Okay, what do we mean by this? Basically, trial hearing, the trial hearing is a process in which situated conduct is transformed into a legal reality. What does the trial consist of? Well, the trial basically consists of a number of trial hearings, a number of subsequent performances. And these subsequent performances are all mediated by texts. So at one level, we're looking at the trial as a process. We're not just looking at the outcome, we're not just looking at the verdict, we're looking at the process of how the verdict is created in performance, in trial performance, and we look at both actual trial performance and the texts that mediate this trial performance. The various texts, written decisions, written transcript that kind of mediate these performances. Okay, so this is the basic thing we are interested in. We're approaching the trial as a process. We're approaching the trial as a trajectory of performances, and as a trajectory of text. Now, one thing that we are interested in is how is this trajectory of the trial in turn connected to intertextual trajectories. And one of these intertextual trajectories is what might be called the trajectory of jurisprudential construction. For example, just this morning, we were looking at the trial, we were looking at trial transcripts in the trial of Dominic Ongwen, trial that will be concluded in January. And one of the things that interests us are the way prior decisions made in earlier trials, how the way these prior decisions are recontextualized in the trial, and the way they set up a standard for current trial practice. A phenomenon that social linguists and linguistic anthropologists would refer to as metapragmatic regimentation. Basically, how do prior decisions by other trial chambers set standards, set a framework for current trial conduct. And in that sense, we're kind of studying how the ongoing trial relates to previous trials. And we're trying to sketch that trajectory of jurisprudential construction and situate the trial within that trajectory of jurisprudential construction. Oof. Sorry. A second type of conversation, a second type of text trajectory we are interested in are the wider conversations that ICC trials are part of. For example, discourses about heritage, discourses about cultural heritage, discourses about transitional justice. How do these wider ongoing societal debates are refracted within the trial? We are looking at dialogical networks and shadow conversations. How do trial actors in the court relate to audiences outside the courtroom? How do they address constituencies outside the courtroom? Again, it is in a way similar to the other trajectory. We are looking at how what goes on within the micro context of the courtroom, within what goes on within the particular setting of the trial, situates itself within broader societal discussions at a global scale. And we're looking at we're then specifically interested, for example, in the way in which these wider conversations affect the participation framework of the hearing. We're interested, for example, in the images of self and otherness that trial actors project in the course of the trial. So that is basically our framework. We look at the trial trajectory, and at the same time, we are tracing or trying to reconstruct how what goes on in the trial relates to the to this trajectory of jurisprudential construction and to this ongoing, to this wider societal context. And that is, in a nutshell, the kind of approach to international transitional justice that we developed, and the way in which we try to analyze this process of judicial emergence and try to see how trial actors attend to such tensions. Okay, let me try to make this a little bit more concrete. Let us look at some examples of actual trial discourse, some examples in which I will try to show how ICC trial actors imagine the court in response to the challenges that we came across. Okay, I will be drawing from one particular trial that we examined in detail, the trial of the prosecutor versus Ahmed Al-Faki Al-Mahdi. A little bit of context. In April 2012, January 2013, in between April 2012, January 2013, the northern Malian city of Timbuktu was occupied by Islamic fundamentalists. At the end of June, beginning of July, members of this group, Ansar Deen, destroyed a number of religious mausoleums of religious scholars and the mosque, basically in the context of of a doctrinal dispute over between Salafists and between Salafists and local Sufis. According to Salafists, praying at such tombs was considered a heresy. At the same time, in July 2012, Mali referred the case to the court. The court started an investigation. And in September 2015, one of the people behind these instructions, the head of the religious police, Mohamed Al-Faki Al-Mahdi, was arrested in Niamey, Niger. He was interrogated, extradited, and just a few days' time, he made the first appearance before the court. All that in September 2015. There was a war crime charge issued in December. The charges against Al-Mahdi were confirmed in the 1st of March 2016. And the trial itself took place in between August 22, 24, 2016. A very short trial, only 3 days. And that's basically because Al-Mahdi pleaded guilty. The first time a defendant before the ICC pleaded guilty. And just 3 weeks later, on September 2017, 2016, Al-Mahdi was found guilty and he was sentenced to a sentence of 9 years. Okay, how much time do you have got left?
Well, you may finish your presentation. We are limited in, I don't know, 2 hours. You may stay here.
Yes, I mean, I can.
Well, we start at 10 a.m. So well, I don't know. You have more 15 minutes. It's okay to you. And after Fábio may talk a little bit.
Okay, I will briefly talk you through 2 examples. Start with one and then see how much time we've got left to go through the second. Okay, the first example is an example taken from the confirmation of charges hearing. And I would like us to have a look at an excerpt from the prosecutor's opening submission in the confirmation of charges hearing. And that was from the 1st of March 2016. So the opening statement by ICC prosecutor Fatou Bensouda. I would like us to have a look at the opening and the closing of the statement. I will briefly read us through the opening and the closing segment. And you can find the fragment itself in YouTube if you would be interested. Okay, Bensouda was addressing the court in English, but I'll briefly be reading you through the English translation. Madam President, Your Honors, Timbuktu is about to lose its soul. Timbuktu is under the threat of outrageous act of vandalism. Timbuktu has under its throat the sharp knife of a cold-blooded assassination. This is the cry of desperation launched by an inhabitant of Timbuktu. That is how she opens her submission. She closes the submission as follows. Well, ladies and gentlemen of the court, the first suspect, Mr. Al-Mahdi, the first suspect, Mr. Ahmad Al-Faki Al-Mahdi, stands before you, Madam President, Your Honors. This is the occasion to tell the victims of the attacks that we have finally heard their cries of desperation. Our investigations are continuing, etc., and we will do everything to bring those responsible before justice. Now, what's interesting here is, if you look at this opening and closing statement, what's interesting here is that the prosecutor kind of sketches, the prosecutor in this opening and closing statement frames the court case as a dialogue with the victims. The prosecutor aligns herself with the trial chamber, the trial chamber as engaged in a common task of responding to the victims. So she opens the submission with a quote from the victim statements, and she paraphrases that quote as, "Ceci, c'est le cri de désespoir que lançait un habitant de Tombouctou. This is the cry of desperation launched by an inhabitant of Timbuktu." That is how she opening a submission, and she closes, "Well, Your Honors, this is the occasion to tell the victims of the attacks that we have finally heard their cries of desperation." So she's kind of using a kind of horseshoe construction to frame the whole case as a response to cries for help by the victims. The victims are crying out for help, and the court responds to this cries. The court responds to these cries for help. Okay, so far so good. Now, what is interesting here is that if we look at this quote, there is actually a very dramatic recontextualization going on. This quote is something that the prosecutor, the OTP, copy-pasted from a television broadcast on the evening of June the 30th. France Info broadcast a news broadcast in which it showed footage of an elderly man reading out a statement, reading out the following statement, and the footing was the footage of the elderly man was framed by the journalists as les anciens responsables pour la culture de le pays, the elderly responsible for the culture for culture in the land express their disconcert about, and then you have the footage of this old man reading out a statement. So this is already something very similar. This is not a lonely visit, a lonely destitute person in the desert crying out for help. No, this is somehow an elderly. This is someone with a mandate from the community who is reading out a statement before a group of journalists, who is making a statement and reaching out for help, who is manifesting himself as a political agent on the scene. Now, if you do a little bit of searching on the internet, you find that this statement, the elderly man himself did not, the man who read out that statement did not compose the statement. The statement itself had been available on the internet since since the 14th of May 2012, and is known as La Déclaration de Tombouctou. And it is again not by an anonymous victim. It is a text that was drafted by the director of the Ahmed Baba Institute, and which had been undersigned by a group of Timbuktu intellectuals. So all this, and then it's interesting to see how, you know, these are not some destitute people in the presence crying out for help. No, this is a group of local actors who present themselves as a political agency. One person speaking on behalf of a larger constituency, one person who knows how to reach out to the international audiences, who knows how to use the internet, who the director of Ahmed Baba Institute had been a research fellow, I think, in New York at Columbia, someone with access to the international scene. And all this is lost in this recontextualization by the prosecutor. And this kind of resonates with a point that Kamari Clark Marx makes in her 2009 book on fictions of justice, in his book Fictions of Justice, and in one of the chapters she describes the tension between the ICC and local reconciliation initiatives in Ugandan context. And here she poses the question, what kind of victim does the ICC want? And I quote, one consequence of the articulations of justice that advocates in international law, that advocates international law over national law, is that it reduces citizens in Uganda and elsewhere to victims whose very exclusion from political life is a necessary condition for political intervention by international legal regimes such as the ICC. The Ugandan amnesty approach, rather than treating them as bare life victims in the fashion of the ICC, allows them to engage with. So there is a tension between, on the one hand, local reconciliation initiatives who approach victims as political actors, while the International Criminal Court kind of requires victims to leave behind all pretenses to political agency. And here she draws on Georgia Agamben's distinction between bare life, mere physical existence, Zoe, and bios, life as part of a political moral, life as part of a moral political community. And this reduction from bios to Zoe is very much this reduction from bios till zoe is very much what we see happening in this recontextualization of the statement in the prosecutor's opening submission, in the sense that the victim is kind of here as well. The victim is kind of bereaved of all political agency, and is kind of reduced to an anonymous, faceless speaker, isolated on his own in the desert, crying out for help. Okay, very briefly, second example, Mohammed Awi from the trial itself. Cross-examination by Mohammed Awini, the lead defense counsel for Al-Mahdi, of the investigator who initially interrogated Al-Mahdi in September 2015 after his arrest in Niamey. So in Niger, Al-Mahdi was arrested. He was interrogated a first time by the investigators for the prosecution. And one of these investigators now testifies before the court, and he's cross-examined by Mohammed Awini. One important detail, Mohammed Awini himself was present during that initial interrogation of Al-Mahdi. He had been present, not yet as his defense attorney, but a kind of requested to be present by the registry in order to protect Al-Mahdi's interests. That was before he became his defense counsel, but he was present. Okay, and then when he cross-examines the defense attorney, when he cross-examines the interrogator, he draws attention to, he kind of recontextualizes that interrogation, and he does that in a very specific way. So he says, okay, I represent the defense, therefore I had the impression that Mr. Al-Mahdi indeed answered to your questions or wished to assume responsibility. Did you have the impression that he was full of remorse and that he spoke the truth through the bias of the words that he chose? He chose to speak Arabic. I think he did so deliberately. In speaking the truth, he wished to contribute to justice. So he asks the interrogator whether he sensed any remorse on the part of Al-Mahdi. The interrogator says, that's not my task to do. And you know, I didn't notice any signs of remorse. I believe I should not try to guess or estimate what went on inside Mr. Al-Mahdi's head and how this has developed. I would make a difference between, or a distinction between, the truth-telling, taking responsibility on the one hand and being remorseful on the other hand. Perhaps, and then something interesting, perhaps in understanding his language, you may have a different understanding of what his feeling was. So he kind of, the counsel is asking, well, did you see any signs of remorse? And the interrogator says, no, I did not see any signs of remorse. But at the same time, there is a kind of very subtle cultural othering going on, a very subtle cultural othering going on, initiated by the defense attorney, a very subtle cultural othering by the defense attorney of the ICC interrogating. The interrogator recontextualizes the written record of the pre-trial interrogation, during which he was present himself, and in doing so, he aligns with the client. I was able to detect that the client was expressing remorse because I understand Arabic and you don't understand Arabic, which is something he's very subtly hinting at. So he's at the same time, in recontextualizing his client's word, he's kind of erecting a subtle cultural boundary between himself and the OTP interrogator. And this is something, and in that sense, the OTP interrogator is subjected to cultural othering. And now I'll very briefly move towards a conclusion. What is interesting in this fragment is that the way cultural otherness is dealt with. If we look at cultural otherness in domestic legal systems, we see that attributions of cultural otherness are typically attributed to outsiders. I did some research on cultural otherness in Belgian criminal courtrooms, and then the cultural other will always be the outsider, the immigrant, someone with a different cultural background. We, members of the court, we have our cultural background. And it's the culture. It's the defendant with the minority background who is the cultural other. And in such instances of cultural othering, you typically see that the defense attorney disaffiliates from his client and aligns with the court. You know, Your Honor, my client is not behaving in the way people are supposed to behave because of his cultural background. So if there are cultural boundaries drawn, the boundary will always be in between the court and the cultural outsider. What we see here, and that is interesting, is that cultural otherness is distributed across trial actors. So in this case, the defense attorney culturally affiliates with his client and treats this guy working for the prosecution as a cultural outsider. And that, I think, has to do with a very a different way of imagining the court. The ICC imagines itself as a court that is not coincident with one particular cultural tradition, but it imagines a kind of plurality of cultural traditions. And you know, that is, these are just a few instances of okay, I'll stop here. But I mean, this is still very much research in progress, but this is, I think, two examples of the way these various tensions and this, you know, complex global political landscape which the ICC is navigating. These are a landscape of political conflict, of cultural difference. These are just a few snapshots of how this landscape is navigated. And this is still very much work in progress. So maybe in a few years' time, when there will be another opportunity to present my research, I will be glad to. Well, maybe by that time I will have a fully fledged conclusion, but at this time, this is still very much incipient work and work in progress. Okay, I hope I haven't been speaking for too long, and I'm afraid I have been speaking for too long. But Pedro, I gladly give back the floor to you.
Thank you so much. Thank you so much, Sigurd. It's very interesting how you take the International Court, Criminal Court as a box. Well, first, there is a black box too, because we often in Brazil talk about that when we referring to justice practices, and it's very interesting your approach to take into account the plurality of speakers, the cultural backgrounds of everyone, and the organization of procedures. And I hope to talk a little more after Fábio, because I have some questions about specific issues. So I pass to Fábio, my dear friend and colleague, and I'm so glad to have you here and to talk to you in this very different condition. You're in Finland, we are in Brazil. And thank you, Fábio. You have the word.
Well, thanks, Pedro. Thank you very much for the invite. I think it's like, as you said, it's a fantastic opportunity to, I mean, kind of like present the work that we've been doing here. I've just been here for like almost 2 months, so I'm kind of like still getting used to the place, getting used to the research. The research has started a few months ago, so Sigurd, like, he has done some like some analysis yet. So, but yeah, I mean, it's as you said, it's something that is ongoing, and we will be glad to talk more about this soon. So, of course, I think Sigurd gave like a very nice overview about the project. So I was thinking more like presenting some of the practical work that we've been doing at the moment, and kind of like reflect and about like how it's to work on this project with this kind of data, with a very interdisciplinary team, which I think it might be useful for like the undergrads and the graduate students that are listening to us. So basically, I want to show like the challenge that of doing the empirical research on the ICC. Well, as Sigurd pointed out, I think the ICC is a very novel form of global adjudication, which is not fully established and does not have like many written rules or sets of previous cases for legal professionals to draw upon. So that kind of like opens up the possibility for us to study how law in action is constantly negotiated within that setting. Another thing that differentiates the ICC from most judicial institutions is the fact that the official transcripts, which is basically the material that we have been working at the moment, they are produced as representing the dialogical character of these interactions. So these transcripts, they are produced by the courtroom typist, who is also referred as the courtroom pianist, due to like their high-skilled task. So the fact that we have this like dialogical transcript that shows like what all the parties are saying, these enable us to investigate not only what the defendant or the witness said, but also how and to what extent these utterances were prompted or elicited by specific lines of questioning posed by the lawyers during either direct or cross-examination, and also by the judge. As Sigurd pointed out, the judge plays a very active role in the case that we've been looking at the moment. So it's kind of like interesting to see these amalgam like between the continental and the Anglo American system, legal cultures. So these transcripts, they are public available on the ICC website, and they are very interesting. They are a very interesting resource to understand, at least partially, the process through which the judicial decisions are constructed. So I think Sigurd said that we are not focusing on the outcome of the case, which is basically how the legal scholars work, but rather on the process. So, which has to do with like what D'Hondt was discussing yesterday when he was explaining like what is the praxeological approach, the ethnomethodological approach to law. So that's pretty much how we've been like looking at the data as a way of like understanding the process through which law, legal categories, and other things are produced within the court. Ideally, we would have like audio or video data for all the proceedings, but these are only available for the opening speeches, like the ones that Sigurd was showing, and also to the closing statements. In any case, due to the fact that the ICC official transcripts, they are dialogical, it is still possible to have a very decent picture of what happens in the court by examining them in a very fine-grained detail. So that's pretty much what we've been doing. We are working with these transcripts, the official transcripts, and also we are starting to look at the video data, especially for the closing statements. We are trying to like look at how those things that were talked about during the interrogations, for example, how they are like used and employed in the closing statements, so we can actually see how these quotes or quotations, how they are like transformed, and we can see that by video, which is great as well. I just wanted to talk about as well how we work here. So we've decided at the moment to focus on two cases. The ongoing case, which Sigurd talked about a bit, which is, as our colleague Juan Pablo calls, the center of gravity of our current investigation. and the Bemba case, which is often used as a point of comparison, as it was one of the first cases in which the court reached a verdict. So we do have like the Bemba case as a point of comparison, in the ongoing case, which is like the main data that we are working at the moment. And I think I was thinking about the way that you, as a research group and people in IAC, how you always work with like the comparison by contrast, by contrasting, especially like in between different contexts, different countries. In a similar way, what we've been doing here, kind of like it, I think it reminds me of that, because the exercise of comparison seems to be very relevant, especially in terms of to identify the differences, because it kind of like it highlights some of the aspects that would have been taken for granted if we have only looked at one case. So by looking at all the cases, it helps us to illuminate some of the features of the cases that we are looking at, the proper case, the main data. So the exercise of looking at the same activities and the same actions and how they are conducted and produced in different cases, kind of like helps us to illuminate how the resources that are used to mobilize and to conduct those activities. For example, we've been looking at the tension between allowing a victim to talk about the psychological harm without going into much detail about the criminal liability of the defendant, or expressing their views and concerns, as Sigurd said. So we've been noticing, for example, that how there are different questioning devices or methodologies for doing so, which are often more visible when we compare by contrast to what happens in different cases. So this is just one example that, just happened, for example, today, this morning. So I think it would be nice to just to talk about the exercise of comparison, but not comparison between different legal systems, but comparison within a data set, for example. And the fact that our main data is comprised of official transcripts and also video recordings allows us to examine the material in which, in sessions that we call data sessions. That's the second thing that I wanted to talk to you. So how we work. Normally, we start reading these transcripts. We read one or two transcripts. We make notes about this, what is interesting, what are the interesting phenomena on these transcripts, which we can identify. And then, as a team, we get together to discuss these episodes or extracts that we find are worthwhile of having a closer look. So these data sessions are very powerful. They are very powerful exercise for exploring, testing, and developing ideas. So we've been having these at least twice a week. We've been trying to keep up with that. And these data sessions, they also enhance the collaborative feature of doing research. And that's one thing that I remember, Pedro. You said to me when I was doing my undergrad project, and I remember you insisting that, well, research is not an individual enterprise. Research is collaborative. And I think that the exercise of doing data sessions, of getting together to discuss something that everyone read and everyone made notes about, it's a very good example of how doing research is not and should be not a solitary enterprise. So although there are other ways of collaborating with our colleagues, I find that data sessions are very effective and very powerful, a very powerful tool for doing so. So that's one thing that I was reflecting upon in the past few weeks, how, to work in a project that, we have 4 people working the project, plus the collaborators as well. So it kind of helps for us to have this exercise. And the second point that I wanted to talk a bit about which I think is also related to what this seminar is about. It's this discussion about interdisciplinarity. So I was trying to reflect on our project and how interdisciplinarity plays a role in it. So our team is comprised of like 4 people, 4 researchers. Sigurd is like the principal investigator. There is Juan Pablo and me, who are like the postdoctoral researchers, and also Elena, who is a research assistant. So all of us, we have different backgrounds, we have different education backgrounds, and we have multiple academic interests. So this means that we will be looking at the data from different angles, using different tools, different methodologies, etc. And this, for me, is especially clear when we are having those data sessions that I was telling you about. So the result of like having these people from different backgrounds and multiple interests is that we have to make an effort to translate our insights and ideas and make them more intelligible for the others, which I think would never happen if we were working alone. We would struggle with that because we probably would think, oh, everyone is going to understand that. But when you're like working with people from different fields, you make an extra effort to try to make your point, to understand, to try to make the others understand what your point is, where you're coming from. So I think it's very valuable, the fact that there is like an interdisciplinary team working with that kind of data. Of course, interdisciplinarity has also challenges, and the main challenge I think at the moment is how to conciliate, how to bring together all these multiple interests and ways of looking at the data in a way that is not only comprehensible for the audience. So for example, when we are presenting in a conference or when we are writing a paper, so it needs to be something that is comprehensible, but also compatible, because sometimes there would be like different methodological approaches that might conflict with each other. So that's a very powerful challenge that we need to address when we are like doing interdisciplinary work. And I think the data sessions are an exercise of doing that and maybe like reaching the ideal point where it's also comprehensible and it's compatible and it makes sense for everyone. I mean, just to finish my talk, for example, I was thinking as well, the fact that in this seminar, you're trying to bring together academia, so like professional researchers and researchers who are graduate students, people who are like, who are in the university, but also the legal practitioners, the legal profession. And I was thinking, for example, in our project, we do have Juan Pablo, who has worked as a legal consultant. And I mean, I was thinking about his role in our team. I think he plays like a very crucial role because not only in providing inside knowledge about the ICC, since he has like worked at, in the court as a legal consultant, but also to help us to re-specify what the legal scholarship has studied about what people actually do within the setting. So we have like, so what people studying from a legal perspective about the ICC? What are the concerns that the lawyers in the ICC have? So, I mean, bringing this knowledge into the data sessions and looking at the data with those lenses, I think it's very interesting, a very powerful resource that we have in our side to provide and to like to give a more complete picture of what the ICC is and how the actors work there. So that's pretty much what I had in mind to discuss today, and I'll give you the floor again, Pedro. And again, thank you very much for the invitation. I mean, I think it's, well, as you and Sigurd said, I think it's probably the only thing that is good in the pandemic is that the fact that we are kind of like, we don't mind to do these like computer mediated events anymore. So we are more familiarized. So I hope we can do more of these. Well, anyway, thank you very much. I'll give you the floor back. Thanks, Pedro.
Thank you, Fábio, so much for your presentation of your experience in this project and the challenges you may face now if there's different experiences to law. You have researchers in Brazilian courts, in United Kingdom Institution of Public Safety, and now in European institution that challenge I think it's a big challenge for the ICC to legitimate itself with this two very different, and I think in many post-colonial society, they are also imbricated, and this inquisitorial and accusatorial model of justice. Well, you Sigurd, present us these, and this is my first question to you, Sigurd. This is, to me, it's a very important characteristic, the mixture of these two models. In Brazil, you do that very often, actually. Brazilian institutions do have some American references, and it's to talk about judicial power and the powers of the judge. Many times they make reference, and for instance, the Lava Jato case, the how do you say that? Well, how to say that? Washcar case, which is widely known about corruption in Brazil. They used a lot of American theories to display Brazilian institutions. And in many cases, another case in Supreme Court in Brazil, Supreme Justice quote on a German criminalist. I forgot his name. It's a theory about the theory of fact in justice. And his German said that if we have a lot of evidence, we may input the how do we say that, the guilty to the defenders without having a very good proof or a very good evidence of what they have done. And this has happened in Mensalão case some years ago. But in Brazil, we have a lot of uses of either American and European philosophies of law to make some discourse about the law and legitimate their actions, even if this kind of practices are not teach in law schools in Brazil. So this is a very innovative way to take into account many theories about the law without taking their meaning, local meaning, into account. So we transform the meaning of these philosophies of law. That's why we have here an inquisitorial model of system, but legal professionals in Brazil cannot recognize that very character of our system. And they still call, for instance, the prosecutors in Brazil, the Ministério Público, the Ministério Público, call himself an accusatorial institution, which, well, you know, which means that the functions of justice are very clearly separated. But here in the practice, prosecutors are just beside the judge in the courtroom hearings, and the courtroom hearings have different functions to our practices. For instance, courtroom hearings in Brazil serve to making records to the judge. The procedure, the dockets, a property of the state. So just to put some Brazilian characters that Fábio are very familiarized, and to show you how in our, I would say, post-colonial society, how do we do that? To put together some accusatorial, adversarial ideas and functions to inquisitorial model of practice, of functioning in the daily life in courtrooms. So I have three questions regarding that very aspect that you and it's a curiosity actually. First, about the right to a process. In the common law tradition, they have this idea of the due process of law. They state due some legal procedures to the individuals. But here in Brazil, well, as an inquisitorial organization of justice, these right in America or adversarial system do not exist in our system because we do not have the right to a process in criminal affairs. But we have the prosecutors and the state ought to put a process. We need to have a process to be prosecuted, and we don't have the right of, for example, a plea bargain or something like that. And that's an important characteristic of adversarial model, as you may know. So what is the nature of this process in the ICC? I really don't know. I understood that they have at least three kind of ways or to refer a case to ICC. But what's the nature of this proceeding? Is it a right for prosecutor, for instance, if they confess, if they negotiate, they can do that. So the first question is that. The second one is what I think it's characterize the inquisitorial systems is the power of the judges. The judges have everything. They have the right to control the production of records. And it means that, at least in Brazilian experience, judges have the right to, for instance, say that an expertise, a professional expertise in the process, in the trial, will not be considered because the judge don't want to. And we may have a lot of these kind of expertises from the different parties, and one asked by the judge himself, and he is authorized to dismiss every expertise we receive. He don't need to take it into account in his decision. Well, this is a very big power to judges. it means that they may dismiss science as a way to understand how conflicts are performed in society. And so what is the power of judges in international criminal court? Do they have these powers of records, of dismissed testimony, and to act by himself as he wish, as he see this decision will fit into the trial? And the third question is also a curiosity, is the function of these transcripts. Well, in my observations during my thesis in Brazil, in France, I'm sorry, I noticed that in France, they have an oral in the first degree of justice. They have an oral procedure, and the records of the judicial institution actually are a consequence of what they have done during the trial. The trial in the first degree in France are very quick. They're very, it's a very, how to say that, loose way to perform justice before an audience. So there is an audience in the courtroom, and I think there is something like that in the ICC as well. But what is the function of register? In France, they make the trial happen and then record all the things they have done. In Brazil, we do the different path. Actually, we record everything we may think it's important, and so defenders through their lawyers may do that as well, but with the judge controlling everything in the docket, and then the decision will be made over this set of documents organized as a procedure, as we call in Brazil, processo, os autos do processo, the dockets of this process. So the decision is not made made during the hearings, after the hearings. It's not common to see that in Brazil, and to me it's a very different way to organize justice. So I'd like to know if you ask yourself about that, or and what is the function of these records to the decisions of ICC. Well, I have these 3 questions because my works are in the comparative approach to French especially, but also my colleagues, and especially my the anthropologist of law, Roberto Canti de Lima, did that decades ago with comparison with the common law system, American system. And so this comparative trick help us to identify some little practice of the daily life in courtrooms, but that changed everything, because the power of judges in the inquisitorial system is very huge in Brazil. But in France, it seems to me to be these powers are continuously to be restricted from to many judicial reforms we have the past 3 decades, and one of them that institutes the how do you say that, le juge d'instruction, le juge de liberté, the judge of liberty, that restrict and constrain the juge d'instruction, celui que, I'm sorry, the one who's making the evidence, put the evidence together to send to another judge to make his judgment. But in Brazil, as the legal doctrine explains to us, it must to be the same person. And so this comparative approach to Brazilian inquisitorial practice and French inquisitorial practice have shown me how we can restrict and constrain these powers of judge. And so, well, these are some reflections to exchange to you with you some ideas, and I'll be very glad to hear from you if you have some idea what can about the nature of the process, the power of judges, and the statute of records in the International Criminal Court.
Okay. Mm-hmm.
It's not easy. I know it's not easy task, but it's just to.
Okay, I mean, let me start by saying that these were the kind of questions that I would be afraid of. I'm not a legal scholar, so I'm not the best person to address these questions. And it's, I mean, actually, these would be the kind of questions that we would pose to Juan Pablo, and why we have an interdisciplinary team. But still, I'll try to address some of your questions. Let me start with the transcripts. What is the role of the transcripts? I think the transcripts are produced by the registry. The registry creates the records. Records are already available on the same day. I mean, it frequently, you come across quite often that, for example, a witness gives testimony in the morning and he's cross-examined in the afternoon, and the cross-examining attorney will be referring to a statement the witness made in the morning, and he might even quote, well, on page 5 of the preliminary transcript from line 7 that you this morning you said this and this and this. So it's a kind of basically it's part of the evidential record of the trial, and they're produced by the registry. They're available on the same day. They're published. They will be published on they're part of the evidential record, and they may be referred to later on in the verdict, for example. They may be referred to in later trial hearings. For example, when an expert witness is giving expert testimony, very often he will be asked, he or she can be asked to comment on certain statements which another witness made in trial. So they're part of the evidential record. As such, they are not controlled by the judge, even though they have to be, they're not controlled by the judge. They have to be released by the judge. And let me see if I have open session. I'm not sure who does the redacting process. Certain transcripts will be redacted in order to prevent the disclosure of any. Before they are published, they're redacted in order to prevent the disclosure of any information that might lead to the identification of a witness or third parties, for example. So I'm not sure who's responsible for that process, but at least what you see online is a kind of, or that judges will be orienting to the production of the record, you know, the kind of similar processes.
I mean, in ethnomethodology, we have some studies that show that the narratives about the process are constructed during the during the subsequent procedures in each institutional context. For example, the article of Baudouin Dupré, L'Intention, an Act, in which he's shown how the public prosecutors in Egypt and police in Egypt do that by recording some aspects to input some intentionality to people. So, well, my question is not a tricky question. Actually, it's a very hard question to seize, because I think the problem in this kind of mixture of accusatorial and inquisitorial model is that inquisitorial model we have a lot of power to judge. And that's a problem to making legitimacy, and that's a problem actually to cultural, how do you say, cultural misunderstandings during the court, because it may be, the judge may finish this kind of misunderstanding by choosing one version or one narrative constructed by the defender, or in this case that you shown us. For instance, the idea of to have a different language in the court, does it does the judge may choose one of these languages? Is there an official language that he must refer?
That's the.
You know, my question is that because if the ICC is, even with this mixture, has an inquisitorial feature. Well, first, I think Fábio can help you a lot, because he has a lot of experience with inquisitorial institutions in Brazil. And it may affect the idea of legitimacy, because in inquisitorial institution, as in France, for instance, they must, the decision and the procedure must be intelligible to people. But in Brazil, it's not a case, because people do not participate of the procedure. The procedure is a power of the judge. You know, it's just a question, but I mean, I do understand your.
One thing that I can say to that is that I don't think there is one party that owns the record, but the record is a matter of concern. So in the sense that a judge, and this is something similar that Listocco, Stocke,
for the record.
You have these kind of for the record statements. For example, when this very often happens during cross-examination, where a judge will intervene and use inquisitorial power and say, well, for the record, we enter that, and you'll have both not a correction of the record, but you'll have this kind of orientation towards the online production of the record, which you see manifesting itself in the record itself. So the judge might refer to the production of the record. And referring to the language issue, that's an interesting thing as well. ICC has 6 official languages. There are 2 working languages, English and French. English and French. Records are produced in English and French. Now, if you take, for example, the Al-Mahdi case, there are de facto, in addition to English and French, there is also, for example, there will also be Arabic. Awini, the lead defense counsel whom we saw, was addressing the judge in Arabic. So when in Ongwen, the 2 languages used are English, French, and Sango. In Ongwen, English, French, I'm mixing up English, French, and Akoli. or some variety of accolade, and then there will be translation into English and French. Now, what you occasionally see is that translation issues are addressed later on in the record. So the record is a kind of online an online registration of everything that is said, and it can be used by parties for making corrections. And again, I've seen it happening that usually in court there are 3 sessions of 1.5 hours, one starting in the morning, another one from 9 to 10:30, another one from 11 to lunchtime, then one other in the afternoon. And very often in the beginning of next hearing, one of the attorneys may bring up, hey, there has been a translation issue has arisen, or there has been this issue which has not been correctly written down, or and that brings me kind of my answer would be that no, it's a kind of very much a kind of, it's not a definitive record. It's something that is incrementally produced and incrementally corrected, and something that also is not owned by one party, but something that is available to all the parties. And for example, in cross-examination, the cross-examining attorney has the statement which very often he has a statement which the witness made in lead examination in front before him. And
cross-examination, it's a feature of adversarial system.
Yes.
Yeah. Inquisitorial system does not have a cross-examination.
So
actually don't have this idea of evidence in inquisitorial. We have the idea of la preuve, or it's a kind of proof. Actually, it's an official statement, it's an official document, something that make the statements, or as by having an official character, and so there is no cross-examination in Brazil. We don't have that in. So it's I think it's an important clue to understand the stature of this kind of records.
And then records, and that's something interesting. Records, once they are so they lead a life inside the trial. I mean, they're part of the official record of the trial, and then they are published on the ICC website, and after they have been sort of cleaned to protect witnesses, but they play a secondary role in the framing of the court as a transparent court.
Well, that's it.
You have this huge. The ICC website is at the same time an archive of its judicial activities, and everything, every document, every transcript, is available there, and of course it's one huge pile of documents, and you have to know how to navigate, and then you have to gradually master the heuristic strategies for finding your way around. But even in throwing up this whole pile, it assists the court in projecting an image of transparency. So the secondary life of these documents is the archival, and the idea of having available a resource, an official resource of all the narratives produced before the courts. That's I think their secondary life, their archival function, which again legitimizes the court through transparency. And then you got the transparency on the website, all the documents are there, but then I don't know if you also see that transparency reflected in the architecture of the court. The image that I showed in the beginning, the glass house structure, and if you go to the court, you move through this glass shell, and if you go inside the courtroom, there are windows on top of, I mean, if you're sitting on the public bench, you can see the blue sky. I mean, there is this literally a court where you can see through. So that's the secondary life of these transcripts. But again,
I think
Juan Pablo would not be. Juan Pablo is not here with us because he would be
all right,
better place to address these legal issues.
but it's a very original institution.
Mm-hmm.
In the middle of Europe, and we have I know adversarial institution like that, and near to France, we know that France has a inquisitorial system that they have restricted through time, but they still inquisitorial. So it's a very original institution for sure.
Yeah, your second question about the power of the judge. I'm afraid I'm not well enough versed in this comparative in this comparative work on comparing legal systems to give any definitive answer. What you do notice is that this compromise is very much negotiated on the spot. And there is a very much sometimes, and this is something that comes up during our discussions, you know, in order to make sense of what's going on, sometimes what you have to know what is the background of this particular, attorney, or sometimes it's very clear that certain judges have a background in an inquisitorial system and play their active role very clear. So I mean, sometimes even there is the question of it is, you see very much different judicial cultures playing out among courtroom staff, and this is often I came across hearings where this is even topicalized by the judge, for example. Well, you know, I've seen it happening before my eyes, that the judge said, well, you know, I am from Germany. Within my legal system, you would be, and he was talking to an expert, you would be approached as an expert here before the ICC. You are an expert witness. You are a witness. So, I mean, people reflect and deliberate on these legal differences in the courtroom. And that is, again, something which I think makes the ICC unique.
It is a carrefour. It's a carrefour of legal traditions in Europe. It is a carrefour of legal traditions in Europe.
And not only European legal traditions. It aspires itself. I would say beyond Europe. But then, of course, one of the issues is say, to what extent is Islamic law present within, and for example, if you look at Al-Mahdi makes references to Islamic law in explaining why he reached this at a certain point. Al-Mahdi supported, he did not support the decision, but he was himself not in favor of destroying the monuments, but he kind of Timbuktu, but he kind of developed a legal argument as a legal scholar that said, well, it is not allowed to have these monuments, but it's not necessary to destroy them. So he drew upon his own expertise as an Islamic legal scholar. He articulated that expertise within the court, and one of the things that we would be looking that would be very much worth looking at is how is that Arabic legal tradition re-articulated, or that Islamic legal tradition re-articulated within the setting of the courtroom. But that's something very much that would be more Baudouin's area of expertise. So, I mean, for the second question, I wish Juan Pablo would have been here, who would have given a much more to the point answer. And your first question had to do with
the right of a process, because in adversarial system they have the right, so they may dismiss the process, they may negotiate, they may bargain, they no, so it's not like in an inquisitorial system that the process is mandatory. The sanction mandatory. It's they must do the process to condemn someone, or convict someone, or something like that.
Mm-hmm.
So it's a obliged passage to conviction.
Mm-hmm.
Like this one you shown us. He pleaded guilty.
Yeah, he pleaded guilty. Yeah.
And what's happened then?
What happened? Okay, very, very relevant question. Al-Mahdi pleaded guilty, and but the ICC does not have a system of plea bargaining.
All right.
So the ICC does not have plea bargaining. What happened in the case of Al-Mahdi was that the prosecution and the defense reached an agreement on certain facts, and that was published beforehand. Certain facts, the defense and the prosecution jointly submitted a list of facts which were accepted by both sides. A list of numbered facts, about this list of facts, there is no dispute between us. Secondly, they had reached an agreement on a sentencing range, within which the other party would not. Basically, it was they had agreed of a sentencing range between 9 and 11 years, and if the chamber would pronounce a sentence within that sentencing range, the other party would not appeal against the judgment. So they had kind of informally determined, well, if the judges pronounces a sentence in between that range, we won't appeal. But that agreement was not binding to the judges. So it was of a kind of a gentleman's agreement, but was in no way binding to the judges. I mean, in the end, the judges stick to the sentencing range and gave him the 9-year sentence, the kind of the minimum that the prosecution proposed for not appealing. But in principle, they could have pronounced the 30, I mean the maximum penalty of 30 years as well. So it is a kind of, and that is interesting. There is no provision within the legal instruments for plea bargaining. So they kind of devised a possibility of plea bargaining themselves within the ICC framework, which is one of the reasons why Al-Mahdi is kind of a landmark case, because they prosecution and defense, they did something that resembled plea bargaining within the framework of the ICC, within the legal framework. Now, that being said, it is, yeah, I mean, there is a framework within the ICC. You have the prosecutor collects a case, then there is a confirmation of charges hearing, during which a trial chamber has to assess the evidence and has to determine whether there is sufficient evidence to let a case proceed to a full trial. So there is a kind of...
But is this a kind of pre-trial hearing?
It's a kind of pre-trial hearing
to set the terms of accusation.
Where the threshold is, of course, much lower than at the trial itself. I mean, it's usually much shorter, and where a chamber will, and very often this will be a single judge chamber, where a chamber has to decide whether a trial can proceed to court. Now, I mean, for example, in the Kenya trials, it has happened that the chamber decided, well, the prosecution does not have sufficient evidence. So there have been cases where you know, the trials were dismissed already at this pre-trial level. So, but in general, it would be a process that is very much determined by the chamber.
So it's a very unique institution. The transparency, I think it's a challenge for this court, and it's a challenge for every court around the world, because courts always try to legitimate through their sentences and decisions and acts and rituals. And it's true that's a challenge to research an institution like that. Well, I just want to pass to Fábio to ask him if he has something to say about these questions, his first impressions about this research. What do you think, Fábio?
Yeah. Well, I was thinking, especially now about this matter of like the being transparency and I mean the legitimacy. I think that's like the main question that we've been looking at. And you can see that in the micro level, for example, there are very several moments in which not even, especially the judge, but also some of the lawyers as well, they put questions to the witness, well, actually to the victims, about, so how do you feel after having told your story here in the court? So this is like a way that they kind of finish their hearing. And you can see like different orientation by the court and by the victim. So the victim is oriented to like, okay, I feel better, but what I really want is just like new prosthetics, for example.
I'm sorry?
A new prosthetic leg.
Okay.
So the victim, they are oriented to a very practical thing. Oh, I need to, I mean, you need to keep an eye on the things that is happening there, or anyway, some very more practical actions by the court. Whereas the court is more oriented to like, I want you to say something that, oh, I mean, I'm feeling more relieved now, or oh, I'm so happy that I'm here because finally I'll have justice. So the narrative that they want, and this is like, has to do with what they consider like the good victims, which is these people who kind of like help them to legitimate their role, what they're doing there. So what they are doing there is like providing justice to these people that wouldn't be able to have justice otherwise. But you can see by the tension between what the victims, how they respond to these questions in a very, I mean, mundane, just wanting mundane things. But this is not what the courts want to hear. The courts want to hear these like master narratives about justice and these like cathartic moments, for example. So I think this like matter of like legitimacy is absolutely vital to understand a court that is, I mean, constructing its own like legitimacy gradually. So it's not in our cases like in, which is, I mean, the national court. I think the matter of like establishing legitimacy has done like a long time ago. Of course, there's like discussions about this, but this is not a problem that the national settings, the national courtrooms, they face. And also about like I wanted to comment about the role of the judge, which also can be addressed in a micro level a way, because you see the way they, how they intervene in the interaction. So you can see like how they transform, for example, if one of the lawyers make a question and there is an objection by the prosecutor, by the defense, for example, oh, I object to this something that you shouldn't be talking about this. It's very often that we can see like the judge, okay, I will address this, and try to reformulate, try to almost save the question that has been objected.
All right.
Something, okay, now what he wants to say is that blah, 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 blah. In order not to like object the question, but actually, okay, let's continue this. So you can see like how he plays a crucial role to like.
This is an inquisitorial power.
In the court.
And Fábio, I'm sorry, but this is an inquisitorial power. When the judges may rearrange the question, may,
yes,
as
yes.
you said, save the question.
Exactly, yeah, they reformulate, and they do that sometimes more explicitly, and sometimes more subtle ways of doing that. But you can see like how they play a crucial role. I remember like when I was first reading one of the transcripts, I was like struck by how often the judge says or asks questions, because I was expecting something that was more like adversarial, like the cross-examination. I was expecting more like the lawyers conducting. But when you see like the role of the judges, I mean, it's kind of like fascinating, and it shows like this kind of a dual role that he plays in these interactions. So I think you don't need to like go to the macro level to discuss this thing. You can see like the very detail of the interaction, like how these like small interventions by the judge, and kind of like they point toward a direction of like what the judge is doing, what he's in the interaction.
Well, do you have something to say more, Sigurd? We are in 2 hours and 20 minutes of meeting. Go ahead.
Just one very brief comment about it as transparency. You say, transparency of the court is a kind of something that all courts would have to address. One brief remark: the transparency of the ICC is very much a staged transparency. And you have, I showed you the building in the beginning with all the glass and the transparency. Now, glass makes things visible, and it makes the judicial process visible. But at the same time, being visible is being subjected to power, and Foucault reminds us of that. So, I mean, walking through the court, and there's something that's one reason why you should all go to The Hague when you have the chance. So if you walk through these premises, I mean, there is this projection of transparency, but at the same time, you're subjectivized by this transparency, and this transparency subjectifies you at the same time. So there is something very ambiguous about this transparency, but that would take another lecture. So let's stop it at this point. I know we have been going on and sorry. Pedro, I think you're muted.
Well, thank you so much for your presentation of the project. I'm very happy and very glad to have you here. And I hope to continue this conversation later, maybe, I don't know, to find some way to collaborate to you. It will be a pleasure to collaborate in this project. Well, first through this participation of Fábio, that is a research member of our group, He's someone that is very special for us because he's very integrated, a collaborative guy that help us and other students to find a way to understand law in interdisciplinary way. So thank you so much, Sigurd, and thank you, Fábio. And I hope to continue this conversation. And I hope to see your work. And when you have some articles and maybe a book in the end of this project, I'll be very glad to read and discuss with you and my students. So thank you so much. And I think we're going to finish our recording here. Well, do you want to say something?
Thank you, Pedro. I mean, this pleasure was all mine. I mean, it was a challenging discussion, but I hope and I'm quite sure we will find time to continue it. Either, well, through Skype, or let's hope one day we will be able to travel again. But thank you for this again.
Fábio?
Well, I just wanted to thank you again, Pedro, for the opportunity. Just like to kind of showcase our project and what we've been doing here, which I think has many connections to what, you've done for a long time and other people have done. The fact that we have like Baudouin as one of the collaborators here, and he's been, very much one of your main collaborators as well, kind of like, there is like a bridge that we can, we can build this bridge and start, continue to this discussion. Absolutely. Thank you very much.
Well, thank you. I'm going to speak in Portuguese to invite people to the next activity. Bom, pessoal, vocês que acompanharam a gente até agora, muito obrigado. Espero que vocês tenham aproveitado essa manhã de muito aprendizado com o Sigurd e com o Fábio. Esse projeto super interessante que eles têm desenvolvido na Finlândia, na Universidade de Jyväskylä, no Departamento de Línguas e Comunicação. E eu convido todo mundo às 2 horas para estar com a gente na próxima mesa, que vai ser a mesa para discutir as demandas por reconhecimento de direitos dos povos de terreiro, com a Amanda Evelyn, que é doutoranda no IAC-UFF, que vai mediar a mesa, o professor Sérgio Negri, da Universidade Federal de Juiz de Fora, da Faculdade de Direito, o professor Ilser de Matos Oliveira, que é o nosso convidado, e vai apresentar os seus trabalhos sobre as demandas por reconhecimento dos direitos do povo de terreiro. O professor Ilser é da Universidade da UNIT, em Aracaju, no Sergipe. Então, nós temos aí uma mesa bastante variada de colegas para apresentar os próximos trabalhos. Estão todos convidados às 2 horas estar aqui. Well, and I'd like to thank you, our staff here. Orlando e Letícia, por favor, vocês podem aparecer antes da gente. Orlando, thank you so much. Muito obrigado, Orlando, pela ajuda. E Letícia, muito obrigado. We are students of the Public Safety Course em Niterói. Muito obrigado, viu, Orlando e Letícia. Tchau, tchau, Sigurd. Tchau, Fabinho. Boa sorte. Tchau, Letícia. Tchau, tchau, Lucas. Até a próxima. Obrigado.